on YouTube. Okay. For the record, today is June 7th, 2022. This is the 8:30 civil trial calendar. My name is Brad Gardner. I'll be the magistrate judge presiding over the calendar here today. When I call this calendar, when you hear your case call, please make the appropriate announcement. And let me ask you this, Mr. Stone.
Yes, sir.
Are you going to be the only lawyer here? Because I see Ford listed, and I think on the mediation report that I read, there was another name that was listed. I think that was Mr. Valdez. That was there for mediation.
I'll be the only lawyer for Landmark Dodge. I believe Mr. Washington's lawyer is also here, Peggy Brown.
Miss Brown, yes. Okay. Position 1 is John Washington versus Landmark Dodge Chrysler.
Ready, Your Honor.
Okay.
Matthew Stone on behalf of Landmark Dodge. We're ready.
Okay. Position 2 is LVNV Funding LLC versus Michael Ramsey.
Here for that case, Judge. Daniel Green for plaintiff.
Thank you. And is Michael Ramsey present? Okay. And there is a counterclaim filed in that case, Mr. Green. So when we get to it, I'll hear your announcement related to that. Position 3 is LVNV Funding versus Taylor Middleton.
Here for plaintiff, Judge. Daniel Green.
Okay.
Yes, present, Your Honor.
Thank you, Miss Middleton. And Miss Middleton, do you believe that there is a possibility that speaking with Mr. Green may lead to a resolution of this case prior to trial?
Sure.
I'm sorry?
Sure.
Okay. And Mr. Green, are you willing to speak with Miss Middleton?
You know me, Judge. Always would rather talk.
Okay. So I'll put the two of you in a breakout room when the time comes. Position 4, Barclays Bank versus Oscar Dixon. And I did not see any of the parties on that case.
Your Honor, I can announce on that case.
Okay.
Let me just find out what's going on with that one.
Okay. Position number 5, LVNV Funding versus Joyce Mitchell.
Here for plaintiff.
And I did not see Ms. Mitchell. Position 7, UHG 1 LLC versus Gene Verquire. And Mr. Johnson has announced.
Here for the defendant, Judge. Derek Johnson.
Here for plaintiff, Judge.
Yes. And Mr. Johnson, do you believe it will be beneficial to speak to Mr. Green about a potential
I was
resolution?
willing to talk, Judge. Absolutely.
Thank you.
Okay. So I'll place you in a breakout room with Mr. Green second after he meets with Ms. Middleton. And finally, LVNV Funding versus Jeffrey Arnold.
Here for plaintiff, Judge.
Okay. So, all right, that completes the call of the calendar. Is there anyone that thought they were going to hear their case called and their case wasn't called?
Your Honor, I have a quick question. Did you call the position 5 LVMV versus Joyce Mitchell? I didn't know if you formally called that one.
I did, and Miss Mitchell does not appear to be present.
Okay, thank you.
So it looks like, Mr. Green, you have two cases where the defendants are present and other cases where the defendants are not present. Now for position 1, before I put Mr. Green in the breakout room, and I'm asking this question to try to figure out how most efficiently to move through this. I know this case has gone to mediation and it was not successful. How many witnesses, Ms. Brown, do you intend to call?
It's just my witness, Your Honor, that's my client.
Mr. Washington?
Mm-hmm.
And is it just going to be Mr. Valdez, Mr. Stone?
Yes, sir.
Okay. Do we have an estimate of how long it'll be?
My side, just to put my client up, should take about 15 minutes.
Okay.
And I probably have a few minutes of cross-examination and maybe 5 or 10 minutes for Mr. Valadez.
Okay.
I do
Okay.
have a preliminary motion, though, Your Honor, that I'd like to ask the court to hear.
Yes, sir. And have you shared this with Ms. Brown?
We filed it last week, Your Honor, so
Okay.
she should have gotten a copy of it.
Okay.
I have not gotten a copy of the motion. What I did get was an affidavit of Joey Tucker, and this is a defense exhibit 2 that I think I received on Friday, I believe.
We also filed a motion to dismiss, but I can just make the motion verbally today, Your Honor. It's in the court record.
Okay. Mr. Johnson. And Mr. Johnson, it appears that you're there with your client. Is that correct?
That's correct, Judge.
Okay.
Just seems to be easier here lately for me.
Your Honor, I could speak to opposing counsel first since they're in person if you'd like.
Oh, to counsel?
Yes, for
Okay.
that case.
Okay. So what I'm going to do is, based upon that, I have placed Miss Middleton and you in room 1, and Mr. Johnson in room 2. So it looks like I'm going to have to.
Oh, sorry.
No, it's no problem. I'm gonna have to open the rooms, and then I'm gonna have to move you to room 2. And then when you're done, I'll move you back to room 1. So you can speak with Miss Middleton, okay? All right. Uh-oh. Okay. So for the purpose of the record, this is going to be position 1, John Washington versus Landmark Dodge Chrysler. Mr. Valdez and Mr. Washington, would you both raise your right hand for me, please? Do you swear affirming the statements you give during this proceeding shall be the truth, the whole truth, so help you God?
Yes.
Mr. Stone, what's your motion?
Honor, we move to dismiss the entire case based on a failure to perfect service of process. The plaintiff filed suit on September 4th, 2020, and they purported to serve Landmark Dodge on October 22nd, 2020. They served a gentleman by the name of Charles McCall, and as set forth in Defendant's Exhibit 2, which is the affidavit of Billy Tucker, the CFO of Landmark Dodge. Mr. McCall is not the registered agent and was not authorized to receive service of process. When we filed an answer on behalf of Landmark Dodge on November 20th, we raised defective service and lack of personal jurisdiction as affirmative defenses. By doing that, under Georgia law, it created a burden on the plaintiff to exercise the greatest diligence possible to get Landmark Dodge served with process. They made no effort to serve Landmark Dodge after November 20th, 2020, when we filed that answer, raising the defects in service and jurisdiction. It is our position, Your Honor, that the court lacks personal jurisdiction over Landmark Dodge for failure to perfect service, and we ask the court to dismiss the case.
Ms. Brown?
Yes, Your Honor. This is I know, I looked at their answer. But first, let me say that I have not received a copy of a motion to dismiss. You can check the record. I check my email daily, and I never received that motion. And now that he told me that he filed a motion to dismiss, I went through my email and I searched, put in the keywords Tyler, Landmark, Washington, and I never received notice of a motion to dismiss. My first time hearing of anything substantial regarding service is when I got their exhibits and I saw they have an affidavit of whoever the person is he just named. I saw that affidavit, so I said, oh, they're challenging service. So I looked at their answer and I see that they have a number of defenses, 11 defenses. So it's, some defendants, and this is obviously one, they put every defense they can think of in their answer. So I had no idea that this was supposed to be a real claim of lack of service. So I am objecting to this case being dismissed. First of all, this case is almost 2 years old. They could have filed a motion to dismiss long before now. And like I said, motion to dismiss that's been filed, I don't have a copy of it. So they could have filed a motion to dismiss long before now. They're claiming that this person, hold on, if you'll let me find find what they filed. I have a lot of papers here. Okay, this affidavit of Joey Tucker says that Charles McCall was not authorized to receive service of process for Landmark. But how do I know that? There is case law that, and actually, let me start with OCGA 911-4E says that that service can be left with the president or any other officer of the corporation or a managing agent thereof. Also, of course, as well as a registered agent. So I don't know who this person is. Obviously, if the police, the sheriff deputy felt comfortable serving this person at Landmark Dodge is because he accepted service. And I'm sure he represented that he had the authority to do so. This is not a new matter for Landmark. In fact, one of the cases that I found, Landmark made that same defense in the case of, you'll give me a second. In the case of Nesmith versus Landmark Dodge Inc., and that is 691 Southeast 2nd 240. They also brought this same defense that their administrative assistant was served, and they tried to say that the administrative assistant did not have the authority to accept service. And the appellate court rejected that, stating that they did not put forth anything to counter that that the administrative assistant had the authority to accept service. So I don't know who this person is that the sheriff served. This person named named Charles McCall. I don't know his position. He could be someone with managerial authority there. So I asked the court to deny their motion to dismiss, which I've never received a copy of. It says in order, that case that I just cited says in order for an employee to be authorized to accept service on behalf of the corporation, it is necessary that the employee's position be such as to afford reasonable assurance that she will inform her corporate principal that such process has been served upon her. And I submit to the court that that has happened. That's why they filed an answer. That's why we're here today. They received notice of the service and they filed an answer. So they have been served since 2020. And there's another case that I want to cite as well. I can't find it readily, but my position here, Your Honor, is that this case is set to go forward. It should go forward. If the court is inclined to say that they haven't been properly served, although, like I said, I don't know who this person is that was served. That person could have managerial authority. I don't know what that person does at the company, but he surely accepted service and he surely got it to the right person that we're here today. I would submit to the court that the case is not right for a dismissal. If the court is inclined to accept their position, I would ask the court to give us the time to serve. And then if we try to serve again and they try to come up with an excuse again that they were not properly served, then I'm just going to serve the Secretary of State. This case has been pending for 2 years and I feel like we should just get it over with. What do they want to do? Just delay the time to hear this case because it's going to be heard. It's not going anywhere. My client is going to file again if he needs to. So I would ask the court to just give us time to serve if the court finds that they were not properly served. But I feel like they are, and I'm asking the case to move forward.
Okay, I just looked at the answer and it looks like the third and fourth defenses were allegations of improper service. And that was filed on November 20th of 2020.
Right. But like I said, if you look, they have 11 defenses. This seems like just a form answer of let us throw out every.
Ms. Brown, stop. Please stop. You have a responsibility to read the documents.
I did read it.
You didn't respond to the allegation. And I'm not even getting there. But I just don't like wasting time with words. I like to cut through and get to the heart of the matter. And I'm not saying I'm ruling against you. So they filed a response, which any responsible business would do upon being served with the lawsuit. Now, I'm aware of case law that talks about service and that the court can take into account a totality of circumstances, but that case deals with personal service on an individual, not on a business. My understanding, and we're going to have a discussion about this, my understanding is that with businesses having a registered agent, the reason that you have a registered agent is so that there is a quick and easy place to serve that business rather than serving that business at at the location, because you may have an employee that's upset, an employee doesn't like what's going on, and that person doesn't do what they're supposed to do. And I'm not saying that that's what happened here, because you raise a valid point that whatever process took place, they were able to get the documentation and get to this point. So, Mr. Stone, what is your response to that argument from Ms. Brown?
Your Honor, the case law is
You're-
clear that just because,
Judge, I'm
Okay.
sorry. Could you send
Yes,
me
sir.
back to the breakout room with Mrs. Middleton? Thank you.
Yes, sir. And I'm sorry. I saw you raise your hand. Let's see. 2, 1, and she's in that room.
Thank you.
Okay. I'm sorry, Mr. Stone.
no worries. Your Honor, the case law is clear that just because a business or any defendant has actual notice of the filing of a lawsuit does not mean service is proper. And here, just because Mr. McCall received the suit papers and they were transmitted to me so that I could file an answer does not mean that Landmark Dodge was properly served under Georgia law. Georgia law requires the registered agent or someone authorized to accept service to receive service on behalf of the limited liability company here. That
What
didn't happen.
I'm sorry.
That's okay.
Did I cut you off?
That didn't happen.
Okay. So what I'm going to do is I'm going to ask both of you to submit to me something in writing for me to review with the cases that you cited, because this is an important matter and I don't want to just blow it off. So I am going to Miss Mary, do you know when my next civil trial calendar?
Let me look. Give me a few minutes.
Judge, we did file the brief on Friday. It was filed and served. I understand the magistrate court doesn't generally accept written motions or have hearings before the date of the trial, which is why I also move verbally. But we have something in writing. I'll be happy once Ms. Brown responds to file a reply brief if that's needed. But and I believe my staff, I contacted them during the hearing, and I believe they're going to resend everything again right now.
Okay. And what I'm going to ask is for it to be sent to my judicial assistant at Mary.Moultrie, Moultrie at ClaytonCountyGA.gov, because when stuff is filed, it doesn't necessarily make it to me, but if it's sent to her, I get it.
Okay.
Mr. Washington, you were raising your hand, sir.
Yes, this is the first time I've ever had to do this with Zoom. You said when stuff does not get to you, and I know it doesn't matter to you or who I'm trying to go against, but this is costing me, and right now it was just a $5,800 that I gave to the dealership. This right now, and I don't want to point the finger, but even with the court system, you guys have cost me $38,400 because one person did not, when we had a mediation, one person did not send it to the right person. I had to stay on the court for a year. It'll be a year next month. My vehicle is costing me $200 a month to leave it in storage. So we talk about mistakes.
Where's your vehicle being stored?
It was okay. I have all my receipts, but I found
and I read the complaint, and I know that you took the vehicle to another place to have it looked at, and there's an allegation that
public storage. And then I took it out of public storage because in 6 months it was costing me $200 a month. Now it's at my friend's, Shakita, which I have every receipt that I had to pay her by, because not trying to point the finger, but this could have been handled I would say literally 2 months after, but it took a whole year because someone didn't have the right email address. And I'm the only one. Well, I'm not gonna say I'm the only one, but I had to stay adamant and persistent. And then I got to the point where I was like, no, I need to know, why is this taking so long? So whoever I don't know if it's called a recorder or whoever I talked to over at Clayton County, they realized at that point in time that they made a mistake, that this could have been done 6-7 months ago. So we talk about mistakes. It's like,
Well, let me just explain what the pandemic has done to the court system. We have estimates of we're not going to get back into regular order probably until 3 years from now because of how everything shut down. And it's a matter of timing. Back before the pandemic, this matter would have been dealt with within 30 days. But that's where we find ourselves. The service issue is an important issue because if service was not done correctly, as Mr. Stone has said, and he's right, I lack jurisdiction unless his client waives the lack of service and decides to move forward. So it's a technical matter, but it is a legitimate matter. So that's why I want to hear from your lawyer before I make a decision, because she has made a valid point. My understanding of the law is that what Mr. Stone is currently saying is what I would have to follow. So before I throw this case out, I want to be able to hear from your lawyer and give it adequate weight to move forward. And the reason I'm putting it back on my calendar so that this discussion doesn't happen all over again. So I'm trying to take responsibility for that.
May I ask a question, Your Honor?
Yes.
Well, first, I would like to state that this is not the typical register agent situation where the register agent is outside of the business. The register agent, where he's to be served at, is at the business. But then, notwithstanding all of that, we'll just have him served. We'll just take it back up to have the sheriff to go back up there and say specifically, you have to serve Alfred Berlanti, and go from there. So I would just ask for time to have them served, which shouldn't take long at all.
And I'll grant you that, Ms. Brown. And the reason I'm trying to put it back on my calendar is so that we can move this case on that day. And this will be done. Mr. Washington can move forward. Whatever decision is going to be made will be made. Yes, Mr. Washington, looks like you wanted to say something else.
On this particular date, if it does occur, there's a service manager by the name of Roberto who may appear also, and he has 35 years of experience with Jeep.
Okay.
Just for the record.
No,
He said that he definitely would help.
that's fine. And my job as a judge is to give everybody a fair shot and fair consideration. And that's what I'm trying to do. So, Miss Mary, did you get that date?
July 5th.
July 5th.
To just grab my calendar, which is out of
Okay.
reach. 1 second.
Okay. And Miss Washington, just so you know,
Yes.
since I started in January 1st of 2021, I've had exactly 1 day off. and I still got work that I'm trying to do and catch up on. So I do feel your pain. I do understand, and I'm not trying to prolong any of this stuff. So, Ms. Stone, does that they work?
That works for me. Joe,
Does
are
that
you
work
clear
for
that?
you, Ms. Brown?
It does, Your Honor.
Okay. So this matter is going to be continued to July 5th at 8:30 in the morning. And
I'm sorry, did you
the,
say 8:30?
yes, sir.
Can
And
you ask them a question, Your Honor? Who is Charles McCall? What is his position?
Ms. Stone,
I believe he's in fleet sales.
fleet sales. Okay. So Mr. Stone, Mr. Valdez, Ms. Brown, and Mr. Washington, you can be excused. And I'll see you on July 5th to have this matter resolved.
I appreciate it, Your Honor.
Thank you.
Okay,
Thank you, Your Honor.
thank you.
All right, bye-bye.
Okay, give me 1 second, Mr. Green, and I'll hear an announcement. I have one other matter that's going on, so just give me about 5 minutes, okay?
No problem, Judge.
Okay. Okay, I apologize. Some days I just want to be like a shoe salesman or something.
Well, Your Honor, I have good news for you at least.
Okay,
We're mutually just requesting a continuance on the UHG matter.
okay.
Mr. Johnson, would you like 30 or 60 days to try and look into this?
And I was gonna say 30 days, Judge. I heard that you, on the other case that you gave them July the 5th, and I'm gonna seek 60 simply because I have a leave of absence for the first 2 weeks of July.
I don't oppose that, Your Honor.
Okay. Miss Mary, what date do
I
I
can't
have
tell
in-
you. I can't
you-
tell you that
you
date.
can't?
for 60 days. Mm-mm.
Okay. So what I'll do is I'll ask for this case to be continued for no less than 60 days.
And Judge, if I could,
Yes,
I tend to speak to counsel regarding this case. If we settle it, you gotta excuse me, Judge, I haven't done magistrate in Clayton in about a year and a half. So I don't know whether or not the procedure has changed. Do we simply present an agreement to the court, or do we wait till that court date?
no,
Okay.
you can present an agreement in advance, but you need to send it to Miss Mary at mary.moultrie, MOULTRIE at Clayton County, GA.gov. Because if it goes to the clerk's office, things just get haywire. So it's better if there's an agreement reached to send it to her with something that I can sign off on.
All right.
Because for some reason, they do not believe that a dismissal by a lawyer means anything unless the judge has signed off on an order dismissing the case.
All right.
Um,
And I don't want to interrupt you, Judge. I apologize.
yes,
August 2nd.
August 2nd.
All right. And Judge, if we do reach an agreement, we'll of course present the order to you. And if you sign off on the order, we'll do a mutual dismissal.
Okay. And what'll happen is it'll get to where it needs to go from the starting point, rather than it gets sent into the clerk's office and they're sending it over. And because we do so much stuff virtually, there's some people that they bring things over as if I'm at the courthouse and I'm not. And if it's not placed in the right person's hands, I may not know that it's there.
All right.
Okay.
All right.
So position number 6, UHG.
I think it is number 7. I'm sorry, go ahead.
Okay. UHG 1 LLC versus Gene Friguire is going to be continued until August 2nd of 2022. And please, if you reach an agreement, just send it over and you will not have to appear
We
on
will.
that day.
Thank you, Judge.
And
Okay.
Judge, that's all I have. May I be excused?
Yes, sir.
Thank you, Judge.
Okay.
Have a good day.
You too. What's your announcement with Miss Middleton?
We've settled this, Judge. If we could continue this 30 days, she's going to submit a payment and we'll file a dismissal.
Okay, that case is going to be continued to July 5th, 2022.
Thank you.
And again, once you've reached an agreement, if it's before that date, just send it in to Miss Mary and I'll sign off on it. And neither one of you have to appear on that date.
Thank you, Judge.
Okay. Miss Middleton, you may be excused, ma'am. Have a good day.
Thank you.
And then, Your Honor, the rest of my cases, I would just propose to submit proposed orders of judgment to Ms. Moultrie.
Yes, please. So that's position 2, LVNV Funding LLC versus Michael Ramsey. And you're going to have to ask in that case for the counterclaim to be dismissed. Position 4, I have Barclays Bank versus Oscar Dixon. Present a proposed order in that case. Position 5, LVNV Funding LLC versus Joyce Mitchell. Submit a proposal in that case. And LVNV Funding versus Jeffrey Arnold.
Thank you, Judge.
Okay, thank
Wasn't so bad of a morning after all.
you. I fell asleep in my chair, sitting here at my chair yesterday after my hearings, and didn't wake up till like 9 o'clock.
Oh no, did you have dispossessories or?
It was what did we do yesterday, Miss Mary? I don't even remember.
Abandonment.
Child abandonment.
Well, thank you, Judge. Have a great day.
Okay, you too.
Bye-bye.
Bye. Miss